Hi, everyone. Thanks for joining us today. We've got a lot to cover, so I'm just going to let everyone sign on for one more minute and then we'll get started. All right, well, we'll kick it off as people are still getting logged in. My name is Cece Mortar, and I'm the programs manager for the Steamboat Springs Chamber. I want to give a quick shout out to our business education series presenting sponsor, Mountain Valley Bank, and supporting sponsors, the Employers Council, Northwest Data Services, and the Colorado Housing and Finance Authority. Without them, these events truly wouldn't be possible, so thank you. A little bit of house cleaning. We'll stop for questions throughout the presentation, so feel free to put your questions in whenever you have them. And then we'd love it if you could use the Q&A feature at the bottom of your screen, and otherwise you can put running commentary in the chat. I would like to take a minute to welcome our speaker today, Tina Harkness. Tina is the General Counselor at Employers Council. She represents employers on a wide variety of employment law topics and is a frequent speaker on legal issues, managing employees, harassment prevention, civil rights, diversity, and more. Thank you, Tina, for joining us. We're very lucky to have you as our local rep. We have a lot to cover, so I'll let you take it away.
Thanks, Cece. I appreciate it. And good morning, everyone. I'm happy to be here. We've been doing these periodic legal updates for the last couple of years now. As you know, if you've been to them, there's a fair amount of activity each year here in Colorado. And we're going to get you up to date on what's happened with the most recent legislative session that just ended in early May, what's still kind of in process with regard to that, as far as bills that some have been signed and become law, others have not been signed yet by the governor and are going to continue through that process for another month or so, and then take effect in early August for a lot of these. So we'll talk about that. We have some federal updates as well that I want to cover for you today. So I'm going to go ahead and share some slides. Tell me if anything's not looking right. Otherwise, we'll go ahead as we are.
Looks great.
Looks good. Thanks, Cece. So this is just the requirements, right? For as we go into this material. For the federal update, some of you might remember from last year, the Me Too Act, which was it flowed from the Me Too movement, right? Where different people in positions of power were exposed as being harassers or engaging in sexual assault in their workplaces. And the legislation that came from that, which was the Me Too Act last year, prohibited mandatory arbitration agreements of sexual assault and sexual harassment claims that were entered into pre-dispute. So they were trying to avoid situation where someone experienced sexual harassment or sexual assault in the workplace and then did not have the opportunity because they had signed a mandatory arbitration agreement to take that claim to a judge or a jury. So a companion act to that passed earlier this year is the Speak Out Act. And this one dovetails with the Me Too Act and says you can't have pre-dispute non-disclosure and non-disparagement clauses, specifically in cases of sexual harassment or sexual assault. So non-disclosure is kind of those gag orders. You can't talk about this. Non-disparagement is you can't say bad things about us. It's pretty unusual for smaller employers to have these pre-dispute kinds of agreements. But just something to be aware of. It does allow these clauses in a settlement of a sexual harassment or sexual assault claim, just like the Me Too Act allows the parties to submit their dispute to arbitration. And if you're one of those employers that does have a general pre-dispute non-disclosure clause or non-disparagement clause, then you can enforce it for any other type of claim. You just wouldn't be able to enforce it for a subsequent sexual assault or sexual harassment claim. And this went into effect at the last December, right when it was signed. For private employers, so this is for-profit and nonprofit that are not government funded. There's been a couple of decisions or a couple of developments to be aware of in severance agreements, since there are some companies that are going through reductions in force as we try to figure out if we're in recession or if we're going into recession and how deep recession is going to be. Those entities need to pay attention to this McLaren-Macomb decision that was made earlier this year by the National Labor Relations Board. So this is the enforcement body for the National Labor Relations Act, which is the act that allows employees to form unions and bargain collectively with their employer. Also in that act, there's a right for workers to engage in what's called protected and concerted activity. So they can talk to each other, they can talk to third parties about their wages, hours, and working conditions to try to get something better for themselves. So this McLaren-Macomb decision says that if it's a non-supervisor, so supervisors can't be in unions, they're part of management, but non-supervisory employees, if we're going to offer them some kind of severance agreement, that severance agreement can't have them waive their right to engage in that collective action. So if it's got a broad confidentiality provision or again, a broad non-disparagement kind of provision, that might go against this most recent decision. So if you're doing any of that as a private employer, then you're going to want to have your legal counsel take a look at it because they might be changing things from what you've done if you've done this in the past. Now, the National Labor Relations Board General Counsel has expanded on the McLaren versus Macomb decision in a memo that she put out just shortly after that decision was issued. And she basically said just offering an agreement that has a provision or language that curbs a worker's protected concerted activity rights is enough for a violation or an unfair labor practice under the National Labor Relations Act. So she went even further with this and trying to maintain or enforce an agreement that has that kind of limitation would be a continuing violation of the National Labor Relations Act. So the National Labor Relations Act doesn't have a lot of teeth to it, but it is something that that we do have to pay attention to as private employers. If you're doing severance agreements, make sure you're not using last year's version and you get the carve out language that complies with this year's requirements. So I think I talked about this last year. I looked back and I believe I did. We were anticipating an increase in the federal salary level that's required for employees who are exempt from overtime. And we were expecting that pretty quickly after the midterm elections last year, but it hasn't happened yet. So I just wanted to follow up and let you guys know that it's predicted and it's expected to occur. What they were looking at is raising the current minimum salary level for someone to be exempt from overtime from $684 per week, which is about $35,568 a year to be exact. They're expected to raise that quite a bit to $900 or $1,000 a week, which would put us somewhere between 46, almost 47,000 and 52,000 a year. Now, those of you who are private employers in Colorado, you're already paying more than or $50K right now, right? For the pay calc order that if you're keeping your employees exempt and you're going to go up to $55K in 2024. So this increase will have less of an impact on you. But my public sector employers, so state, local governments, special districts, and nonprofits that are publicly funded, funded with taxpayer dollars, that will impact you because you are probably, again, working off of that lower number, and you may not be up and above 50,000 a year with your exempt employees at this point. So we'll see where that goes. I also wanted to point out a Supreme Court decision from earlier this year concerning exempt employees that kind of caught some folks by surprise and was widely publicized for that reason. And this was an oil worker who was a tool pusher, whatever that is. He was earning between $1,000 and about $1,300 per day, so more than $200,000 per year. And he was paid on a day rate, and he sued for overtime. That's a pretty steep price if you're talking about that kind of money and time and a half for every hour that that person is working. And he won because of the day rate. So exempt employees have to be paid under a salary basis test. So that's a weekly amount that isn't affected by the quantity or the quality of their work. So this employer thought that surely we're paying this person enough that we don't have to pay them overtime, but they were wrong about that. So if any of you are doing day rates, that's not the same, according to our US Supreme Court, as a guaranteed salary. So you're going to want to speak to your counsel about making adjustments to that process going forward. So finally, we're getting to we have gotten to the end of the federal public health emergency that ended on May 11th of 2023. So there's a lot of things that are going to change as a result of that. I've tried to point out some of the ones that affect employers most, and we will talk about public health emergency leave when we get to the Colorado section. So it's not on the slide, but we are going to talk about that. So one thing I want you to know about is that I-9 flexibility that you have had not to personally look at the physical I-9 documents. You've enjoyed that flexibility for the last couple of years in COVID. That ends July 31st of this year. You get a grace period for about another month till the end of August, but then you're going to have to find a way to, again, get those documents physically in your hands, not copies, the actual documents, to do your I-9 verifications for your newly hired employees. That's all employers in the United States have this requirement for the I-9s. Some vaccine mandates are going away. That's pretty narrow these days anyway, since there weren't that many of those left. Some insurance plan coverage changes are happening. The COVID tests, the vaccines and treatment, some of that cost sharing, some of those limits on cost sharing are going away, as well as extended timeframes for special enrollment under the Health Insurance Portability and Privacy Act, COBRA deadlines. Some of those were extended or suspended during COVID, and some of your health plans, claims and appeals deadlines were extended or suspended during COVID. And hopefully you've seen and are aware that some of your employees might be losing their health insurance if they had health insurance through Medicaid or CHIP. And Colorado is doing a 12-month unwind process. And again, you don't have to have insurance or put people on insurance that don't qualify for your insurance, but you may have employees in that circumstance, and having resources to direct them to the marketplace and other sources of potential coverage for them might be helpful. Another change that just happened recently that was on its way. Oh, Cece, did you have a question? Is there a question? You're muted, honey. Sorry.
Yeah, we have one question that came up. So you can qualify for an exempt status just on the basis of your salary.
No, it's not salary alone, but that's one of the 3 requirements. So thank you. That's a very good question. It's salary and then being paid on a salary basis, which that Helix case violated. And then it's also the duties. And that's the trickier part, is you have to have duties that the US Department of Labor considers to be exempt. So thank you for that clarification question.
Thank you.
Yeah. So oral fluids drug testing. So this is US Department of Transportation. So for those of you who employ commercial driver's license drivers, so those are typically people who drive other people around in different vehicles, or people who drive the large semis around. So if you have CDL drivers and other heavy equipment, right, then you may be able to take advantage of oral fluids testing down here, down the line. So urine testing has been the requirement for decades under the US Department of Transportation rules. And now that we've got other types of testing that are frankly more cost effective and have different advantages to them, we're going to have oral fluids be an option for employers. So the rule is effective June 1, but you will have to wait. You can't just start oral fluids testing right then on June 1, because the Department of Health and Human Services has to certify the laboratories to make sure that they have all the right protocols and procedures in place for processing oral fluids tests. So it'll be a little bit delayed, but once there are government certified laboratories, you could switch over to oral fluids tests. And they are less expensive. So that's one of the things that's an advantage I didn't put on the slide. But they also, more easily allow for direct observation of the testing to reduce the likelihood of adulteration or tampering of a drug test, which comes up in the urine testing. It also detects recent drug use better. So it can even detect if they've used right after they've used. It doesn't have to, as urine testing or the hair follicle testing does, it doesn't have to be metabolized by the body. But there's a disadvantage there too, because there's a shorter detection window. So here you can figure out if somebody's used certain drugs a month or more after they've used them. With urine, it can be days or weeks or more. This is going to be a shorter detection window, which could be, I guess, an advantage too, as you think about it. And we will end up with legal fights over oral fluids tests, because urine analysis has been the regular testing for years. People have sued over and over again over how that has been done. We really don't have those cases built up on oral fluids testing yet. So there'll have to be some fights about that too. So you're going to get some new federal posters. So this is everybody. The FLSA poster is required now. So I've given you the link. You can go out and get this and cover up the one you have with, you can print it out on your printer and cover up the one you have for now. For those of you who are private sector employers with 50 or more employees, you need a new FMLA poster. The public sector employers, you're covered by FMLA regardless of size. Well, let me just go back for a second. There is a new FMLA poster, but as it says on the slide, it is not required. So if you have a 2016 or a 2013 version of the FMLA poster, you can get by with that. You're not going to get penalized if you get an FMLA claim and you don't have the most current, but you can update it. Also, there is a new EEO poster coming soon. It's not out yet. So that will be a required poster, unlike the FMLA. So you might want to wait if you're buying those 6-in-1 or 5-in-1 combined federal posters. You might want to wait to replace your full poster until that EEO poster comes out, because then you don't have to buy another new one. So that's why I say for the FLSA poster that's required now, maybe you just go to this link and you print it out and cover up the portion of your all-in-one federal poster for the time being, and then you get a brand new one when the EEO poster comes out. So artificial intelligence, it's not just for writing college papers anymore. Employers are increasingly using that for productivity tools in the workplace. In some cases, they're using it as a recruiting and a hiring tool. And I don't expect that is going to diminish or change. I think there'll just be more and more uses of AI. So the different federal agencies are just expressing to businesses that you have to use caution when you use any of these tools, that you as the employer are liable for software you purchase. And you have to ensure that there's no illegal discrimination going on with that program. So I think you probably have read or seen different stories about artificial intelligence, not being biased in some ways because of how it's built and the information that it goes out and finds having an underlying bias in it. So the EEOC just issued earlier this month a technical assistance document for how to assess if that software algorithm that you're using might cause what's called disparate impact, which is the unintentional kind of discrimination. And you could still be sued for unintentional discrimination if you have what you think is a neutral test or instrument in place, and in its application it discriminates. You have to you can still suffer a lawsuit. And if you are able to show that there's no less discriminatory way to do what we need to do, which you can still use it because it's an unintentional kind of discrimination, but more likely you're going to have to tweak it or change it to try to avoid that system or process discriminating unintentionally. So the EEOC is hearkening back to some old guidance that it issued back in the late 1970s for how you assess disparate impact in a neutral instrument like an artificial intelligence tool that you might be using for your selection process. And then we also had a joint statement issued by the Department of Justice, Office of Civil Rights, which enforces the public accommodations requirements of the Americans with Disabilities Act, the Consumer Finance Protection Bureau, which is a consumer watchdog typically for financial instruments, the Federal Trade Commission for communication kinds of instruments, and again, the Equal Employment Opportunity Commission. So we'll see more develop in this area. And actually one of the programs that I'm looking forward to at our employment law update in August is going to be on generative artificial intelligence. So we'll see where that what that adds to this analysis. You've also probably gotten some information or read a little bit about the Federal Trade Commission proposing a rule that would really limit or prohibit non-competition agreements. Again, not every employer uses these, but these are those agreements that say, if you leave us, you're not going to go to a competitor or open a competing business for a period of time after you leave us. So it might be a year. It's usually not much more than 2 years in Colorado. And these have been disfavored in Colorado for some time because of state law that limits when you can have non-compete agreements. And we had a change last year to our state law on non-compete agreements. This would be federal. So this would be across the nation if you're operating in other states, and it would do more than even the limitations that were imposed in Colorado last year. So this has got pretty strong business opposition. There's also the possibility that Congress would review this and put it on hold. So this is not a done deal, but we are, if it's implemented, there's going to be some fights over this, and it will really curtail if it goes into effect as it is, non-compete agreements. You've also probably seen a bunch of stuff on labor unions. Labor unions maybe in places that you're not used to seeing them, in Starbucks, at Amazon, the New York Times, at Trader Joe's, at Apple. So there has been more labor actions, more strikes, more work stoppages, and more union representation. It's still historically low in the United States, but there has been a trend upwards. So I've given you some information on this. And the other thing that I think is important that's really different is how people feel about unions. So you'll see the Gallup information here saying that 71% of Americans approve of labor unions, where that was only 48% in 2010. So there's definitely been a shift in how we all feel about unions and the sectors that they're coming into. All right, let's get to the Colorado stuff. So some of you have been used to the comps order, or prior to the comps order, the minimum wage order changing every year. And so we got a lot of calls about, where's number 39? And there is no 39. Comps order 38 is still in effect. So they separated out the minimum wage and the tipped minimum wage and the exempt salary and the highly compensated salary into the pay calc order. So that one will be updated every year, but the comps order won't necessarily be updated every year. So these are where we are now, numbers wise, for all of those different roles. And the Colorado wage and hour pay calc order and the Colorado Wage Act is only applicable to private employers in the state. So those of you who are public employers, you can skip this slide. Family, we know we're in the midst of that. We've been paying premiums this year. We're at a point, we'll see in our timeline in a moment, where we're remitting that to the state. Leave and benefits won't begin until 2024. And hopefully everybody sussed out what level you're participating at, or whether you're not participating, because there were some opt-outs that were available. And for the private sector, some of that stuff is still being worked out. So if you are going the route of providing the same or better private insurance plan instead of participating in the state family, you're probably still working on that and those details and getting your plan approved by the state. For those of you who are smaller employers with 9 or fewer employees, you're only required to remit the employees portion of the family premium. You do not have to contribute, although you can contribute the employer portion. And then the public sector employers, you had to do a vote on whether you were going to opt partially out or fully out, or just participate in that program. And those timelines for some of this stuff have passed. We just had the deadline for Q1 premiums, right? Those were due at the end of April, and you have a grace period until May 31st. So a little bit longer to get those in. Payments that are submitted after May 31st are going to be subject to penalties. So you don't want to be late with that. Cece, is there a question? You're muted again.
But I'm sure you anticipated family would bring in some questions.
Sure.
If we elect a private plan effective July 1st, 2023, and previously did not opt out, can we opt out by January 2024 and get a refund of paid in family taxes to the state?
So, so you'll see on that 2023, it talked about, it shows that October 31st of this year is the approval deadline for your private plan. So, and if you get your private plan approved, you had to start paying in January, but if you get your private plan approved by the state by October 31st, 2023, then you could get premium reimbursement If you do it anytime after that, they're not going to reimburse your premiums that you paid for the beginning of this year, but you still have a window of time, yes, to get your private plan in place and get your premium, get it approved by the state and get your premiums back for the first part of this year.
And then one more question, please clarify how the 9-employee limit is set by the state. My understanding is that it is set January 1st of each year. If you're staffed up for winter, you're in. If employee count dropped the rest of the year, you end up having to pay all 12 months.
I don't know that. So, so if you've talked to the state, that might be the answer, but I can investigate that for you.
Thank you, Tina. That's it for now.
Okay, thanks. That's a good question. All right, so here's where we are in the timeline for family. So yes, so right now, if you're a private employer subject to family, if you are looking at those private plans, they're available now. They've been approved by the Division of Insurance. The rules are out on what they need to do. So you could be working on that right now to set up your plan. And employees will be able to start applying for family in the fourth quarter of this year, but they won't get any benefits until next year. There was a legislative update to family from this session, and this has been signed and become law that requires that the benefits that an individual receives from family be based on a similar calculation to what they do for unemployment benefits. So what they do there is they'll look back at what's called the base period, which is not the quarter we're currently in, and it's not the previous quarter, but it's the 4 quarters before that. So if we were calculating that now, right, we're in Q2 2023, we would discount Q2, we would discount Q1, we would look back at the 4 quarters of 2022 as to what that person had earned from all employers that they had worked for in that base period to figure out what the family benefits will be. So that change has been made. Originally, family was going to base the weekly benefit amount for benefits on earnings only from the person's current job that they were in at the time of taking leave. And they decided that wasn't going to be appropriate. They needed to have a longer window, a longer look back, in case that person was making substantially more or substantially less in their current role than what they had made over the recent past. So that is effective. So Colorado Healthy Families and Workplaces, this is the law that went into effect January 2021 for all employers in Colorado. And this is the law that has both the paid sick leave requirement and the public health emergency leave requirement. And the paid sick leave, of course, will continue. The public health emergency leave was a one-time allotment of leave due to the current public health emergency. And that now that the public health emergency has expired, that remaining public health emergency leave, if you have any on the books for your employees, will expire 4 weeks after the end of the public health emergency. So public health emergency ended May 11th. So that puts our date for expiring public health emergency leave as June 8th of this year. So that those allotments can actually go away. You don't have to continue to carry those on the books. But of course, any accrued paid sick leave, right, is going to continue beyond. That's not tied to the public health emergency. Another legislative action on Colorado Healthy Families and Workplace from this session, which is not yet signed, but we don't have any information that the governor will veto this, so we expect it to be signed. And if it is signed, it's effective on August 7th, adds different reasons employees can use accrued paid sick leave to include bereavement situations and situations where they have a family member who doesn't have school or their place of care for other reasons besides something like COVID. So weather, loss of power, water, or heat, or some other unexpected occurrence, or if someone has to evacuate their home for those same kinds of reasons. So there's just going to be more more reasons employees can take the accrued paid sick leave, and it's probably going to require a policy update for your handbooks this summer. Colorado Secure Savings Program launches July 1. This is promoting retirement savings. There's some scary numbers about how few private sector employees don't have access to retirement plan through their employment. So this creates an IRA, basically, an automatic enrollment IRA. So it covers employers with 5 or more employees. The business needs to have been active for at least 2 years, and they have not offered a qualified retirement plan. So employers who do offer qualified retirement plans just need to report that they have that, and the state is going to look up your 990s. So they'll check your plan, your different tax filings that you do for your plan. They'll confirm that you have it, and you're good to continue going on. So there was a timeline to phase in entry for this. So employers with 15 to 49 employees most recently had to get up and running and participating in the program, or do their own private plan by May 15th. And then the 5 and more employees will be by June 30. And employers with fewer than 5 employees have the option of participating in this program. So one of the bigger bills that passed through our legislature this term is it's called the POWER Act. And this is not new this year. You might have heard some discussion about it last year and in prior years. So this amends Colorado's Anti-Discrimination Act and defines harassment differently from the federal law under the Civil Rights Act of 1964. So the first 4 bullets are really the same as before and as the federal law. That where we're going to depart from the federal law in Colorado is harassment will no longer need to meet this threshold of either being severe or pervasive to be actionable. So, so that is lowering the bar for what it takes to prove harassment in the workplace as an employee. So this increases the risk and the liability for employers. Excuse me, I'm going backwards. So what they're going to do instead of severe and pervasive is they're going to have this totality of the circumstances test that could consider multiple factors that are on this table on this slide. So some of these things were looked at in evaluating whether conduct was severe or pervasive before. So pervasive, you see frequency on this list. You know, severe, whether it's threatening, what is the type or nature, right? If a power differential exists. So some of those things went into that evaluation before of severe or pervasive. But since they're saying it doesn't have to reach severe or pervasive, what we're going to have to figure out through cases on the POWER Act is how much different it is. I think we can expect again that the bar has been lowered in Colorado for proving harassment in the workplace. We just don't know how low, and that's going to come from the cases that we see after this takes effect. And I think we have, August 7th as the effective date for this, assuming it's signed. And again, Governor Polis doesn't veto that many bills. He vetoed the wolf reintroduction and something else this session. It's not expected, but we'll see. Cece?
So this question takes us back just a little bit to the sick leave. Can you please confirm that while paid sick leave can be carried over, employers have no requirement to pay over 48 hours of sick per year?
That's right. The maximum requirement under the Healthy Families and Workplaces Act is 48 hours of accrual and use in a 1 year period. You're correct.
Perfect. Thank you.
Sure. So power, one more slide on that. Employers have a defense to these claims. Again, even though the bar is lowered and there's going to be more risk and more liability for employers, there is still a defense to supervisory harassment, not coworker harassment. But if an employee is able to prove that conduct rises to the level of unlawful harassment by a supervisor, then the employer can assert a defense showing we have a harassment prevention program, right? We have communicated that program to our employees, and the employee unreasonably failed to use that program. So that's the same kind of affirmative defense that's available again under federal law, under Title VII of the Civil Rights Act of 1964. So that is consistent. So you do want to make sure that you've got those preventative measures in place and that you are communicating those things to your employees. Some other things that Power will do is void non-disclosure agreements, except in very limited circumstances. So again, those are like those gag orders. After a claim is made, we don't want you to talk about what we did to settle it. They'll be more limited. And then employers will have to retain discrimination complaints for 5 years. And of course, that's going to be used, right? The Civil Rights Division is going to ask you if you've had those claims, and they will potentially use that in future claims if it seems like you've got some kind of systemic problem going on in your workplace. Another piece that passed through our legislature this year will change your applications. So your employment applications, not right away, but as of July 1, 2024, you won't be able to ask on applications about age, date of birth, or dates of attendance at educational institutions on that initial application. So if you have those kinds of questions, you may have already taken off age and from your application just out of concern for age discrimination claims, but you probably still have those dates of attendance at educational institutions, which could be used, right, to some precision to determine someone's age. So that's what you're going to want to look for. There are limited exceptions. Sometimes employers have to know someone's age, such as if they're employing a minor and in certain industries. But it's for the most part, you're going to have to get that off of your application form by next July. Equal Pay for Equal Work Act. This is our friend from 2021. There's another bill in the legislature to beef this one up, which is going to make it more administratively burdensome for employers, unfortunately. And it's going to give the Colorado Department of Labor and Employment additional authority to enforce violations against employers. And they can issue warnings. They can, under this new law, impose civil penalties if they wish to on an employer that's a subsequent violator. And the back pay is also going to go up if somebody is able to prove that they were paid inequitably based on sex or sex plus another protected factor. The back pay awards were up to 3 years, and now they're for the entire time of the violation up to 6 years. So that is quite a lot more than was in place previously. And for your job postings, which I know we've struggled with having to do all this additional information in job postings, you're going to have to add the date the application window is expected to close to your postings. And you're also going to need to post information about who you select to the coworkers that they're going to regularly be working with within 30 days of that person being hired. So this is a new, totally new piece of the Equal Pay for Equal Work Act that didn't exist prior. So this is as not effective until January 1 of 2024, but this is going to be more work, unfortunately, on that front. Cece, go ahead.
So does Employers Council, or will they have updated employment application examples?
Yes, we will. We definitely do have them in our HR forms now. And I think we even have, ones that are, because you almost can't have a one size fits all anymore. Ones that are good for Colorado, ones that are good outside Colorado, but we will be updating those.
Okay, perfect. Does it matter for internal posting versus external posting?
Well, so the Equal Pay for Equal Work Act only requires internal posting to your Colorado employees. But if you are also posting externally, yes, you are going to need to put that same information in there.
Okay, so under no circumstances can we list open until filled?
Well, it's a good question, and we don't know, because again, the legislature just passed this. It's not signed by the governor yet, but we expect that he will sign it. He hasn't said anything about going to veto this. So that is going to be what gets tested, right? So I would say, not to put yourself out there as a target, and maybe put a date, and then you might have to extend that date or repost positions, which isn't unusual for employers to do. I would just try not to be on their radar as a test case.
We will also have Tina back in September to give us some updates on the things that are not yet signed in here. So just keep that in mind too.
Yeah.
Still a couple more questions, Tina. Can we legally ask if an applicant is over the age of 18 or if the applicant is between the age of 14 and 18 for temporary summer employment?
Yes. So that is one of those situations where you have to ask under the Federal Fair Labor Standards Act, which applies to virtually all employers in the United States. So that's, you can ask not their date of birth, but are you at least 18? If they say no, you can ask for proof of their age. I wouldn't do that on the application. I would do that separately. And then you'll know what child labor regulations you're subject to under the federal and the state law. Because 14 and 15-year-olds are more regulated than 16 and 17-year-olds.
Perfect. Application deadline. Must there be a reasonable window established? For instance, if you have identified someone for the job, the applicant is aware the posting is going to launch. Can you keep the posting just for a few days?
Yeah, there is the language from the Equal Pay for Equal Work Act is it has to be open for a reasonable period of time. So if if your window is short, but that's what you usually do as an employer, then yes, I think you can have that short window. My company, for example, just decided on 10 days for a posting to be open. So we just have them posted for 10 days. Now that's maybe longer than a few days, but there's nothing to say that a few days isn't reasonable.
Perfect. What are the processes or requirements for posting who was hired? Is the company physical bulletin board sufficient for posting?
Well, we don't have those details yet, so that may come through some rulemaking. And again, it just has to be to the people that they're going to regularly work with. So it's not as wide a net as maybe the bulletin board, but you could use that if that's something that that you use to regularly communicate with your folks of changes in the workplace. I don't see anything that would prohibit that or prevent that. So then probably what you're going to do is say to your employees, this is where you look for that stuff. just like we did when we first had to start posting, right? This is where you look for our job postings that tell you, right, what's open.
Can you repeat what you said about posting information on the selected candidate to coworkers?
So it's right here on the slide, and Cece will share that with you. You're going to be required after January 1, 2024, so you got a little time yet, to post information on the candidate you select to the coworkers they're going to regularly work with within 30 days of making that selection. And there are specifics in the statute of what you're going to need to post. So it's going to be the name of that person, their former job title, if they worked for you previously, their new job title. And then it's going to be information on how other employees, right, can demonstrate interest in future opportunities in your company. So we'll get more information on this before Jan 1. And last time the Department of Labor was a little slow with this, but they did actually provide some sample language for what would be an acceptable job posting. So we'll have our eyes out for that. And hopefully I can provide that update in the fall.
Perfect. Thank you, Tina.
Sure. Few more things. Protected military leave under our state law went up from 2 weeks to 3 weeks. So public sector employers, you're paying for that leave. Private sector employers, employees can use their paid leave, or they can take that time unpaid, but they get reinstatement rights. So if they return within that 3-week deadline, of course, you're putting them back into the job that they had prior without any impact on their pay, benefits, or what have you, because of their military leave. That's already passed and signed into law and was effective in March. So sometimes the bills that pass through the legislature have an immediate effective date, and sometimes they're delayed. Then we also have, you might have heard a little bit about this, employers are going to be required, not for this year, not for this tax year, but for tax years after January 1, 2023, you're going to have to provide employees with an annual written notice of available income tax credits. So one time a year, and you might be able to use your accounting firm or bookkeeper for that. It's going to be about the federal and state earned income tax credit and the child tax credit. So it's just to try to give people information so that they can save money on their taxes. And there is a bill that passed that isn't yet signed by the governor, but allows an employer tax credit if you help your employees purchase a home. We're getting close, I promise. Another bill I wanted you to be aware of allows minors and their parents to sue employers for basically violations of the Youth at Work Act. So Colorado has its own set, in addition to the federal set of child labor restrictions, that's called the Youth at Work Act. And that limits the hours youth can work, the days of week that youth can work, especially during the school year and then non-school year. So if a minor is working in violation of that Youth at Work Act and they get hurt when that happens, then the minor and they're their parents, it's going to be their parents, right, can sue you outside of and in addition to workers' compensation. So those of you who do employ minors, I mean, you already know that there's a heightened risk if a minor gets hurt on the job. That's already true under the federal rules. The penalties are 10 times what they are for adult workers. But this is an additional area of potential liability. Now, if that minor, because they are going to be covered by workers' compensation for those injuries, if that minor has received workers' compensation benefits, they're going to offset that into against any additional amounts they recover. But normally they wouldn't be able to pursue anything additional. So this is, again, raising the stakes, raising the liability if you employ minors. And then another piece that's just something to know that a bill passed, became law in April that allows the Colorado Department of Labor and Employment to pay employees for a wage claim if the employer doesn't pay them within 6 months of the Department of Labor making the decision that the employer owes those wages. So if the CDLE does that, then the employee can't come after you further, but the CDLE is going to pursue reimbursement from you, employer. So just know that. And I think this is our last slide. So for public sector employers, so state, local governments, special districts, nonprofits funded by public funds, there's going to be a limitation on non-disclosure agreements. So maybe just don't have them because there's lots of limitations on them now. So government employers won't be able to require applicants or current or past employees to sign non-disclosure agreements except in very narrow circumstances. So there's just a whole lot of legislation about restrictive covenants that's going to make it difficult to do. And then as we've seen in the Colorado legislature in several other bills, we are allowing public employees to bargain collectively. It's not the same as unions under the National Labor Relations Act that private employers have to deal with, but it does give public employees additional rights to bargain with their employers. So instead of a union, they can form an employee organization and participate in that. And they can bring unfair labor practice charges, but they can't compel recognition of that employee organization by the public employer or compel collective bargaining if the employer isn't interested in that. So that is a ways out too. That's not till July 1 of 2024 when any enforcement will begin. Of course, you could start dabbling in that area earlier. That's what I got for you. It's 10:28. Cece, do you have other additional questions?
Not yet, but I can start closing out as people type in their questions. If you guys have any last minute questions, please put them in either the Q&A or the chat now. I do want to thank everybody for joining and their time and participation today on this series. Is super important to us, and so we look forward to continuing working with the Employers Council. I will send out the session recording, slides, and Tina's contact information this afternoon, and we will look into and get back to you guys on the employee limit for family question that I think it was Jackie had. For upcoming business education events, as I mentioned, we have Tina coming back in September where we can give some updates on some of these. We are also kicking off our marketing series on June 15th with the first session on social media for small business and nonprofits. That session is going to cover connecting with and growing your audience, creating content and content strategy, and increasing engagement and visibility. So I'll send more information in the follow-up on how to register for that as well. I want to thank our sponsors one more time, presenting sponsor Mountain Valley Bank and supporting sponsors the Employers Council, Northwest Data Services, and the Colorado Housing and Finance Authority. I have one more question in here, Tina. What states of employment law does Employers Council cover now with remote workforce issues?
Well, our region is pretty much Colorado, Utah, Arizona, and then the contiguous states of Wyoming, New Mexico. Oh gosh. All right. And we do have California licensed attorneys. There's 7 states. So I'm struggling to come up with the last one there, but we do have resources for 50 states. So you know, if you're located in Colorado, but you happen to have that remote worker far flung from you, we can still investigate and answer questions. That's okay for lawyers to do that without engaging in the unauthorized practice of law. So we do have 50 state resources where we can find where we can find information. It's just not maybe the same as having it's not going to be the same as having an attorney in that state.
All right, well, that's the end of our questions. I will send Tina's contact, or if you have additional questions, you can ask me and I can work with her to get you the information. Thank you all for joining. Thank you, Tina, so much, and I look forward to having you back.
You're
Have a great
welcome.
day,
Everybody have a
everybody.
great day. Bye.